share something really important today, but before I kick off, I want to point out the sellotape on my glasses. And no, I'm not applying for the role of a young Jack Duckworth on Coronation Street. I sat on them, they broke. I went to the opticians, Appleman Charman in Hoddesdon, very good. And my new glasses are arriving next week. Now, this isn't a legal tip, but I'd encourage anyone buying new glasses to make sure you've got a spare pair as backup. Otherwise, you look like me, and everyone you meet thinks you got your glasses out of a skip. Anyway, I'm Nino Cafaro. I'm a solicitor, and this is Talk Legal with Nino. And today I'm talking deputyships, very similar to lasting powers of attorney, or LPAs as they're commonly known. But whereas with an LPA, the person making the LPA has capacity and gives their permission for someone to make decisions for them. If someone already lacks capacity, they can't legally give that permission to someone else. So if you want to make decisions for that person, you have to apply to the Court of Protection, and a judge has to decide whether you are the right person to act. Now, you have to be over 18, not bankrupt, and the court might apply further restrictions. For example, you might have to demonstrate your ability to manage another person's financial affairs. If the court doesn't think you're the right person for the job, it might appoint a panel deputy instead. And that's a professional person, usually a solicitor, who's registered with the Court of Protection. Now, they won't know the individual they're representing, although they might meet with them once they're appointed, and they're going to charge the individual for their role as deputy. And I want to focus on young adults. Consider a young person, just 18, with special educational needs, and they lack capacity. It isn't a legal given that the parent steps in to assist in decision making. So consider this: you spent the last 18 years making decisions for your child. Now they're 18, you can't. Whilst the court is more likely to grant you deputyship for financial affairs, it's more reluctant to grant deputyships for personal welfare decisions. And I appreciate it can be difficult to accept that your role as the de facto decision maker is now diminished, and you suddenly have to be receptive to the influence of third parties over your child's welfare, but that's the legal position. Now, the court's logic is that if your child has carers, then they may be best placed to make personal welfare decisions. Educational decisions can be made jointly with you and their teacher. It might seem a little intrusive, but it's probably what you've been doing up until this point anyway, taking advice from appropriate professionals involved in your child's life. Now, that said, if the court thinks family members should be appointed deputyship for personal welfare, it'll do that. But the point I want to make here is deputyship applications can be lengthy, complex, and require specialist advice. So before making an application, get the right legal advice from someone who works in this area of law. Given that applications can take many months and can involve multidisciplinary teams, you might want to consider getting that advice well ahead of your child's 18th birthday. Don't forget to hit the like button if you found that useful, and for more fun, informative legal tips, advice on glasses, hit the subscribe button. See you on my next video, hopefully without sellotape.